What happens if a relative by marriage is handling my grandparents' estate and I was never notified about the death or estate filing? In North Carolina, the lack of notice does not automatically cancel the will, undo the estate case, or give you property. But it can matter, especially if you had a direct legal interest and should have been identified as an interested party. The first question is whether you have standing. A grandchild usually needs a direct financial stake. For example, you may have standing if you would inherit if the will were set aside, or if an earlier valid will left something to you. Being upset, being family, or believing your grandparent wanted something different is usually not enough by itself. Next, look at the estate file at the clerk of Superior Court in the county where your grandparent lived at death. The file should show when the will was admitted to probate, who applied to handle the estate, who was listed as heirs or beneficiaries, what notices were mailed, and whether inventories or accountings have been filed. If the will was admitted in common form, a person with a legal interest may be able to file a will caveat. That is the usual way to challenge whether the document is really the valid last will. Common grounds include lack of mental capacity, undue influence, fraud, forgery, improper signing, mistake, or revocation. The usual deadline is within 3 years after the will was admitted to probate in common form. If a caveat is filed, the clerk transfers the dispute to Superior Court for a jury trial on the validity of the will. While the caveat is pending, distributions from the estate are generally stopped, and the personal representative must preserve the estate assets. So the practical answer is this: get the estate file immediately, confirm the probate date and notice history, determine whether you have a direct legal stake, and act quickly if there are valid grounds to challenge the will or the administration.